This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please subscribe to my channel, and if you want any immigration advice, please get in touch with me. Today I'm going to be talking about the effect of the Nationality and Borders Act 2022 on asylum seekers. This has been in the news recently, both with the cancelled Rwanda flight and the proposed tagging of asylum seekers. If you are thinking of claiming asylum or making a fresh asylum claim, then do get in touch with me as soon as possible, as the current changes are quite extreme and very hostile, as everyone knows. As of the 28th of April 2022, the Nationalities and Borders Act has been enacted and has been touted as one of the largest reforms in immigration law in the United Kingdom since 1971. This is especially true for asylum seekers, as now that Brexit has granted Parliament complete sovereignty and can now grant asylum seekers leave of less than 5 years leave to remain, as was under the EU law, the government have seized the opportunity. The Nationality and Borders Act has in effect created a two-tier system where asylum seekers may be treated differently based upon their actions. Group 1 refugees, there are two types, are classed as those that enter the UK via lawful means, and Group 2 would cover those that enter the UK via clandestine or illegal means of entry. Group 1 refugees are those that arrive in the United Kingdom directly from a country or territory where their life or freedom was threatened and they have presented themselves without delay to the authorities. Group 2 refugees are those that do not meet the previous criteria, and the Nationalities and Borders Act gives the Home Office the ability to treat these two groups differently in relation to the length of any period of leave to enter or remain that's granted, the requirements that must be met to be given indefinite leave to remain, whether the condition to maintain or accommodate themselves and any dependents without recourse to public funds is attached to any period of limited leave to enter or remain granted, and whether leave to remain or enter is granted to members of the refugee's family. So these are fairly important changes. What is crucial to note is that there will be a change coming to the immigration laws, specifically paragraph 339 QA, which will be enforced from the 28th of June 2022. This will allow the Home Office to grant Group 1 refugees the standard 5-year period of leave to remain, which is what they do at the moment. And those that fall into Group 2 will be granted limited leave to remain for a period of 2.5 years. Those in Group 2 are in an invidious position because they will have to apply for asylum again, and this will entail a reassessment of the facts and a potential refusal where they had previously been accepted as refugees. What this in reality will mean is that the Home Office is creating further work for itself. This will undoubtedly materialise into increased delays in processing time and add to the increasingly abysmal and failed asylum system. Of course, there are some 73,000 people already in the backlog. This also sends a message to asylum seekers that the Home Office will remain suspicious of you despite you having proved your case already. There is a further reform to the standard of proof required to establish an asylum claim. Previously, all an individual would need to do was show that there was a reasonable degree of likelihood that they would be persecuted in their home country. This has been upheld for some 34 years and set out in the case of Siva Kumaran. The Home Office would, all they would have to do is merely accept the truth of the account to a lower standard of proof, which the courts have upheld. As from the 28th of June 2022, the new Act will bring into force a two-limb test where the first limb is decided on a balance of probabilities, a much more stringent test than it has been in the past. And this is that the individual has a characteristic that would cause them to fear persecution for reasons of race, religion, membership of a particular social group or political opinion, or has such a characteristic attached to them, and does in fact fear such persecution in their country of origin or former habitual residence as a result of that characteristic. Once this is established, the standard of proof will be applied to decide whether the applicant should be returned to their country of nationality on the basis of whether they would be persecuted as a result of the characteristics mentioned above, and they would not be able to get sufficiency of protection. In practice, this would translate into asylum seekers and legal representatives having to gather more evidence at the start of the asylum case rather than at the appeal. This is a fairly dramatic raising of the bar for those who want to claim asylum. The only saving grace as it stands, and it's only a small one, is that those that are in the backlog or have outstanding cases, or people that claim asylum before the 27th of June 2022, the old regime will apply. So if you want to ensure that you don't get caught out by this new and particularly onerous act in respect of asylum, it's important to claim asylum quickly. So in short, the Home Office from the 28th of June this year is going to divide refugees into two groups. First group will get the 5 years and be treated as asylum seekers are generally. The second group will only get 2.5 years and will have to reapply for asylum and will have less rights attached to them. These are fairly dramatic changes and perhaps have been overshadowed by the Rwanda flights and the tagging, but are likely to have a greater lasting effect on people that are coming to the United Kingdom in search of protection. I hope you've enjoyed this video. I'll be doing a longer video on this in the future and on some how to make applications. Thank you very much again for watching. Do stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.